Welcome to Audit the Court, where we examine the legal complexities that emerge from trials, hearings, and court proceedings. In today's episode, we're exploring two hearings from two different states, each confronting the same problem: criminal cases that had languished for roughly 3 years without resolution. Let's dive right into our first case. Defendant Carlos Anthony was charged in the 30th Circuit Court in Lansing, Michigan, with 3 counts of armed robbery, 1 count of assault with a dangerous weapon, and 1 count of retail fraud. The case was originally charged by the Ingham County Prosecutor's Office before being transferred to the Michigan Attorney General's Office. The case was filed in Circuit Court on March 2nd, 2023, and had been pending for nearly 3 years when, on January 28th, 2026, the matter came before Judge Rosemarie Aquilina for a final pretrial hearing, the last scheduled conference before trial, with Assistant Attorney General Michael Doby appearing for the people via Zoom, while Mr. Anthony and his attorney Ronald Berry appeared in person.
And has there been a plea offer in this? This is a final pretrial.
There has not been, Your Honor, in discussion with the defense attorney.
I'm sorry, sir. You need to stay closer to your mic. We can't understand you.
I apologize, Your Honor. No, there has not been a plea offer made in this case. In discussions with the defense attorney, it was made clear that the defendant would only accept a misdemeanor, so there was no real negotiation beyond that.
Counsel?
First of all, I don't discuss the subjects of our negotiations. We had a conversation. I don't know that I ever said that he would accept any offer, let alone whether it's misdemeanor or felony. In this matter, he maintains his innocence, and we've negotiated as such. Where we're at right now is Mr. Doby had indicated to me 3 months ago that he was going to follow up with law enforcement about getting discovery that's outstanding, and I haven't heard anything since. We don't have the body cameras, the motor vehicle camera videos, anything of that. I understand this is the AG case was transferred to the AG's office from Ingham County.
Wait.
But this whole we don't have it.
Stop a minute. This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years. What's going on here?
Your Honor, a lot of the things that he has requested simply don't exist. 4 body cam videos were located by a subsequent search by the detective sergeant now
A subsequent
on the case.
Yes,
and
next to the microphone. So you said a lot of what is requested doesn't exist. And then what did you say?
4 body cams that had not been previously provided to my office were provided. They have been provided via a download link to Mr. Berry this morning.
Via what?
A download link, a link to download.
Download link. Okay. So, is there outstanding evidence that you have not provided to defendants in 3 years?
No.
Are you?
Well, frankly, Your Honor, I'll have to talk to Mr. Doby to find out when this stray email must have been sent for me to download some additional body camera. It's interesting. I'm being told that much of it doesn't exist, which what I'm asking for is body cameras and dash cameras. And then in the same vein, being told 4 body cameras are sent to you. I don't know. I guess I'll have to look at them. But I know there's lots of law enforcement that were involved with this. They're referenced in the police reports. And to be simply told they don't exist, I want to get some follow-up on here. I guess I'll have to file a motion to compel, and we can get evidence.com records to prove whether or not they exist and what efforts Mr. Doby has taken, if any, to actually retrieve them.
Okay, I have a solution here. And Court of Appeals is down the road if neither one of you like it. So today is the, 26th? No. Yeah. My brain's already finished. Today's the 28th of January. Whatever's outstanding or whatever, can this be figured out by February 4th?
Oh, not that quick.
Why not?
Well, I currently have another.
Don't care. Because they have to come up with it, not
okay,
you.
There's only one me, and I have lots of work.
I know you do.
So
that
quick, I cannot.
Wait a minute. You have a list of what you need, right?
Yeah.
Okay.
Well, I mean, I don't know what exists. By all police.
Not your job.
Yeah.
Not your job. Sir, turn over everything that exists.
Yes, Your Honor.
You
That's
can
happened.
go through, it's gonna take 10 seconds. You could do it right now. I'm happy to wait. You can go through your email on your phone. Just don't say anything yet. You can go through your email on your phone, whatever, and look, and if you never received it, I'm inclined to dismiss this.
Well, that part we clarified.
Okay.
He gave me back in November a download with 172 files. We had a screenshot,
Okay.
and I confirmed with him that I have downloaded those, and that even in his own material, that those do not include law enforcement recordings. He's at least providing an update that there apparently he found 4 police videos. I don't know. He's never emailed or communicated with me about that. But if there's a download,
when did you find those 4?
I'm sorry, I didn't find them. The detective sergeant now, I have no access to evidence.com or whatever the Lansing police use. But the additional 4 videos, so the entire reference 176 items. So sending everything again was sent this morning to Mr. Barry, like within the last half an hour.
So the 4 additional cameras were sent this morning, and I've received no additional information. Okay, now I understand.
Okay. Well, let me understand.
They didn't exist before this morning, apparently, Your Honor.
How long has this? Here's what we're doing. This case is dismissed.
I'm sorry, Your Honor. There's been no motion to compel. There has been you're dismissing these because only because Mr. Barry says.
Together and you can reissue it. This file is 3 years old. This man is due a speedy trial, and this information is not new. I rarely do this. I can't think of one time in 22 years I have done this, but this seems to me to be unfair and prejudicial, and you can reissue. You can take your time and reissue when everything's put together, and then we're going to do all this again. And am I causing taxpayers money? Yes, but you know what? This man has been reporting to pretrial services for 3 years. The date of this offense
respectfully, he is not.
Respectfully, if you interrupt me again, you will be picked up and put in lockup for contempt. So I'll give you a chance to talk, but you will not interrupt me, especially when you're on Zoom, and I've given you the courtesy to not plow through the snow like everybody else, and you're on Zoom. This offense occurred February 15th, 2022, and I am not a judge who just dismisses things lightly. And you can ask everybody in this town, you can go down to the Court of Appeals, and you can do whatever it is you want. But this man has been under our charge for 3.5 years or so, and things have not been turned over until now, and now I'm hearing they need more and more time. There's constitutionally protected rights. When you all get here, and there's no statute of limitations on a life offense. So when the Attorney General gets their act together, so will everyone else. This is dismissed for lack of progress and prejudice.
Your Honor, I need to make
Court of Appeals down the road. Yes?
Can I make a record here, Your Honor?
You can make whatever record you want as long as it's respectful and don't.
Judge Aquilina dismisses the case for lack of progress and prejudice to the defendant. Discovery in Michigan criminal cases is governed by Rule 6.201 of the Michigan Court Rules, the Reciprocal Criminal Discovery Rule, which requires the prosecuting attorney to provide the defense upon request with materials including police reports and law enforcement recordings, and imposes a continuing duty to disclose such materials as they are discovered. Where a party fails to comply, the rule authorizes the court, in its discretion, to enter an order that it deems just under the circumstances. In the 2026 case of People v. Searcy, the Court of Appeals of Michigan affirmed a trial court's dismissal of murder and assault charges without prejudice as a remedy for the prosecution's discovery violations. The court explained that a trial court has discretion to fashion a remedy that fits the violation, balancing the interests of the courts, the public, and the parties while considering the causes of the violations and the actual prejudice to the parties. Here, because the dismissal was entered without prejudice, the people remained free to recharge Mr. Anthony, a point that Judge Aquilina made explicitly in noting that Mr. Doby may reissue the charges.
Absolutely. Thank you. Yes, Your Honor. This case was charged by the Ingham County Prosecutor's Office. It was almost a year before
you
the
have to stay,
AG.
Sir, it's my court reporter. You got to stay near your microphone. The Zoom, for whatever reason, is not picking you up very clearly.
Thank you, Your Honor. This case was originally charged by the Ingham County Prosecutor's Office. It came to our office approximately a year after that for about a year and a half since I've had it, the defendant was on bench warrant status, not reporting. He is, despite repeated violations before and after that. I don't believe that there is any basis. I don't believe that there is any basis for dismissing this case.
Sir. It dropped after bench warrant status.
He's on bench warrant status, not reporting.
Yes, Your Honor. He was on bench warrant status following a violation. He was just on the idea that he has been reporting to pretrial services for 3.5 years. That's not accurate.
Well,
I don't believe that there is any basis for this dismissal based on the defendant.
Sir, you gotta start again. The court reporter's not picking it up.
Your Honor, I don't believe that there is any basis in law for this dismissal based on the defendant's claim that there is additional discovery that has not been provided. There has been no order to compel, no motion to compel, and no showing that there has been any wrongdoing by any party here.
Okay. The bench warrant that I have was in 2024. We are in 2026. The first witness list that I have here from the people was in 2024, August of 2024. This is a final pretrial. My expectation on a final pretrial is that you are all ready, not that we go back to square one like when he was charged. And you certainly can file a motion for reconsideration or do whatever it is you want to me, but this is truly unconscionable here. In August of 2025, he was held in contempt and served 17 days. So between August and now January, there was plenty of time for this evidence and the files from both sides to get in order. I don't know why we're at final pretrial and now there's claims of things that have been in possession of law enforcement and the Attorney General and I suppose the Ingham County prosecutors for all these years and not been turned over. So as far as I'm concerned, a lack of progress is violating a fundamental right to presumption of innocence and freedom. And believe me, I don't do this lightly. I understand these are life offenses. They're very, very serious. But so is the lackadaisical attitude, maybe on both sides, maybe on all sides. I don't know, but I'm not going to stand for it. The resolution is to either file a motion for reconsideration or simply recharge defendant. No, we're done with this file.
Your Honor, may I ask the court issue the order so I don't have to worry about an objection, 7-day rule and all that?
There's one right there, print it. We'll send it over to him and I'll sign it. Just do the blank one. I'm not, so sir, I suggest you're not skipping town. You got another file in front of me. I suggest that you are the most law-abiding person on the planet. I don't like what happened here. I don't like these charges. I don't like this whole situation. But you do have a right to a speedy trial and a right to have an exchange of information that is timely. And this is simply disturbing. And I know everybody's busy. No one knows that more than me. And I had 100% criminal docket. I get it. But this speaks to laziness on your part, your counsel's part, the prosecutor's part, the Ingham County prosecutor's part, and that's not a justice system. That's a lazy system. That's not what I'm going to tolerate. So message sent. They may very well reissue, so I suggest that you deal with your attorney and maybe you continue working on this. I really don't know. I'm not giving you legal advice, but they do have the option of reissuing this immediately, and they can do that. But message sent, I hope. That is all. I'm going to sign the order. We're going to, counsel's writing it. We're going to send it to you, sir, for approval, or I'll just read it now on the record.
Yes, Your Honor.
All right. This matter is dismissed without prejudice for the reasons stated on the record. Any objection to that, counsel?
No, Your Honor.
On behalf of the Attorney General?
None beyond what I've already stated.
Great. Send a message to your office. I expect timeliness, especially on a final pretrial. You all get your ducks in a row, or this will happen. I don't know what else to say. I have not done this in 22 years, but this does not sit well with me. Well, make sure you all get a copy of this. That's all for this record.
Thank you, Your Honor.
After Judge Aquilina dismissed the case without prejudice, the people moved for reconsideration of the dismissal. On April 23, 2026, Judge Aquilina granted the motion, vacated her prior order dismissing the case, and reinstated the case. As of the date of writing this episode, the case against Mr. Anthony remains open. Our next hearing takes us to Washburn County, Wisconsin, where defendant Nicholas Contreras faced charges across 3 separate cases. In the first case, filed on September 8, 2022, Mr. Contreras was charged with second-degree sexual assault, strangulation and suffocation, taking and driving a vehicle without consent, and misdemeanor battery. A misdemeanor case filed the same day charged him with battery and disorderly conduct, and a third case filed on November 23, 2022 charged him with felony bail jumping. The day before the final pretrial conference was scheduled, the state submitted a request to dismiss multiple charges. The next day, on February 27, 2025, the matter came before Judge Melissa Mogan, who presided via Zoom from the Burnett County Courthouse, with Mr. Contreras represented by defense attorney Adam Welch and the state represented by Assistant District Attorney Christian Ness.
We're set here today for the final pretrial in all of these cases. I have received and reviewed the state's request to dismiss 22 CF87 along with 22 CM52. I've reviewed the basis for that request in the fact that the court or the state believes that after thorough review and preparation for the trial, the state believes that they lack further merit and they could not be able to prove to a jury beyond reasonable doubt and prove guilt beyond reasonable doubt in these 2 matters. First, I'm going to ask the state for a more thorough statement as to those cases, and then I'm going to ask the state if that is applicable to 22 CF 114, which is a felony bail jump. The basis for that felony bail jump is being on the felony bond in 22 CF 87 and being pulled over in Burnett County and operating with after revocation. So therefore, Mr. Contreras was driving without having a valid operating privilege. So Mr. Ness, first off, does the request to dismiss include 22 CF 114?
No, Your Honor. I submitted a request for the 2 that are scheduled for final pretrials today. I think that the factual basis and the reason for the dismissal is separate from the bail jumping case.
So we're continuing with the jury trial for this felony bond?
I don't believe it has been set for trial yet.
Oh, I'm proceeding with this trial on that date and time.
Okay. My understanding is it hasn't been set for trial. I'm fine.
Oh, no. All of mine are backed up. If one resolves, then it goes to the other one, and then it goes to the other one. So this court will proceed with trial on that felony bond case unless the state is telling me it's dismissing it or it's resolved, and that's here today. Because we have the jury trial set and scheduled already in these cases, and all the time, that is this court's policy. It is always fallback. If one resolves, then we move on to the next case for that jury. And if that resolves, we move on to the next case. So in this court's, in looking at this case and in these cases, we are set to go to trial then on March 25th for a felony bond jump, unless the state tells me here today that it is either dismissing the matter or the matter has resolved.
Understood, Your Honor. I don't object to that. The only reason I did not think that was because the calendaring, it has been set for a status conference today and for that date. I don't put it on my calendar that way. I'm not the one who sets it on my calendar, but that's how I work. So if you need time to talk to Mr. Welch to see if it can resolve, we can have a later hearing today since this is our final pretrial, and you can inform the court on whether or not we're going to proceed. But at this time, I am not dismissing any matters until I hear what's going on with 22 CF 114. Well, understood, Your Honor. I don't think that further discussion is necessary. I think that the parties have thoroughly discussed possible resolution. I just don't think that there is a resolution at this time. I could talk more thoroughly about 22 CF 87 and 22 CM 52. In each of those cases, it's the same victim. The victim in both of those instances has requested that the cases be dismissed and has made statements to my office to me, including that because of a traumatic brain injury, she has no memory of any of the incidents that are the factual basis for either of the crimes, and that she would not be able to testify to any of the facts within them. And so I believe that constitutes essential facts under both of the cases. And so without that testimony, I don't believe that I can proceed.
Mr. Ness explains that the complaining witness in both cases told his office that because of a traumatic brain injury predating the incidents, she has no memory of the events underlying the charges and would not be able to testify to any of the facts. This concern goes to the foundation of the state's case. In the 1970 case of In re Winship, the Supreme Court held that due process requires the prosecution to prove every element of a charged offense beyond a reasonable doubt, the most demanding standard in American law. That proof must come from admissible evidence. And under Section 906.02 of the Wisconsin statutes, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of that matter. A witness who has no memory of the events likely cannot demonstrate the personal knowledge the rule requires. And in cases like this, where the charges arise from conduct alleged to have occurred against a single person, witness testimony is often the principal and sometimes only evidence establishing the essential facts. Accordingly, Mr. Ness concluded that he could not prove his case beyond a reasonable doubt without credible testimony from the complaining witness.
When did she have this traumatic brain injury?
I think she's had this for years, Your Honor.
She's had this for years, and prior to, are we talking prior to these incidents occurring?
Correct.
And from 2022, from July 27th, 2022, and from July 28th, 2022, up to February 27th, 2025, I'm hearing that the state in no way, shape, or form ever talked to the victim in any way prior to those dates and times, which were going on 3 years, 2.5 years, never from that time spoke to the victim about her TBI and whether or not she would recall any of the incidents and as they occurred or any of the facts. That's what I'm hearing. So I'm hearing that we've had a tremendous waste of resources. Is that what I'm hearing, Mr. Ness?
No, Your Honor.
That's what I'm hearing.
Your Honor, I've spoken to this victim previously. This was a revelation later on in the case. She has, frankly, Your Honor, I'm not certain that I find her statement regarding her traumatic brain injury to be entirely credible. But if an individual is making that statement to me and is indicating that they would not testify to the essential facts of the case, I don't believe that I can call her and expect to prove a case beyond a reasonable doubt.
You still have a duty to subpoena her and call her as a witness, even if she is a hostile witness, and you have the ability to at least try and prove the case, because we are talking, there may be allegations against her. There's a take and drive without consent. There's disorderly conduct. Those are things that you may not need the victim to have full ability to recall and to testify about, correct?
That may be true, Your Honor. I've discussed this with the district attorney. I think it becomes a delicate issue because the public policy consideration is not to treat victims of crimes as though they are criminals. And I think that the forcing a hostile victim to testify and putting the force of the state on them through a subpoena, I think it violates that public policy consideration of my office.
So from July 2022 up until just recently, and I'm going to say, I'll even give you a little bit of credit, last week, up until then, victim was, yep, I'm ready to go. I recall all of these things. Let's go. And then last week or a couple, I'll even give you 2 weeks. She was like, oops, nope, I don't recall. That's how it went down?
No, Your Honor. This happened previously. It has been discussed with, there was a request. I made a statement on the record regarding a witness changing her story. The defense attorney at the time met with me in my office with an investigator. I disclosed what had happened and what was being discussed. There was a proposal for a global resolution as to all cases, and I believed that it was possible to resolve these matters globally on a misdemeanor basis until recently.
And Mr. Welch, there is what I'm hearing, at least from Mr. Ness, and I'm going to not take into account the two serious matters, but to the felony bail jump, there's absolutely no way that this matter is going to be able to resolve and we're going to trial.
It certainly could resolve if Mr. Ness wants to, but there's not a resolution right now.
Because I can give you the day.
Because
Because today was my day.
If Mr. Ness wants to talk about it further, I'm happy to talk. If he tells the court that there's no point in further discussions, then we'll have a trial.
Mr. Ness?
Well, Your Honor, my understanding is that the proposal from defense is to plead to misdemeanor bail.
Your Honor, I'm sorry.
Fine.
Sir,
Well, no, and Mr. Welch, I'm going to ask you anyway. I have the right to ask what the offer is. I have the right to reject any offer in the public interest. And if he's saying it's a felony bail and your offer was to amend to a misdemeanor bail, boom, there.
Understood, Your Honor. I just don't want to create a situation where the court's pressuring either side. So
I'm not pressuring
I
any
didn't say
side.
the court was. I just was trying to head off that possibility, but I apologize.
My pressure to both sides are we going to continue to use government resources since 2022 until 2025, and then go forward with a trial with a felony bail, which I am fully prepared to do. I have 2 days set aside on my calendar, 2 full days set aside on my calendar, which is a lot because I am a very busy court. So I have 2 days on my calendar to have this jury trial. So I just need to know if there's a potential ability to resolve or if we are proceeding in a jury trial fashion.
I think I've made a proposal to the state, and if the state wants to discuss it further, I'm happy to discuss. If the state is just telling us that there's no reason to discuss further, then I'm prepared to go to trial as well.
I don't think that it's likely to resolve, Your Honor. I don't think that there's a point in further discussion.
All right, then we're going to jury on March 25th for a felony bail bond violation case. Everybody's ready to go?
Your
So
Honor,
that means I need everything filed. Today was the deadline, but I'll give you a week to get everything filed. I'll extend it to a week since there was misunderstanding as to how this court functions. 1 week. All discovery, all witness lists, all motions in limine, all necessary documents needed for the trial. And we will see you on March 25th. And I'm going to tell you, this is my drop dead date. That means I will not accept any agreement past today. We are done with negotiations. We're done with resolutions. That means this trial will proceed. The only way it will not proceed as a trial is if Mr. Contreras pleads guilty to the charge. Whatever the resolution is, that's for argument's sake and for whatever can be negotiated. But with regards to that, either he pleads to the charge or the state dismisses it. But we're going to trial March 25th on a felony bond violation. Because we all have that day set aside. Court has it set aside. I have it set aside. Mr. Contreras has it set aside. And it is in the public interest to keep this matter moving. It is a 2022 case. We are now in February 27, 2025. Do we have any questions?
so Your Honor, is the court signing the orders then on the 2 other cases?
Mr. Welch asks Judge Mogan if she was going to sign the dismissal orders. Now, although the decision to file criminal charges rests within the discretion of the prosecutor, Wisconsin law does not give the prosecutor unilateral authority to end a prosecution once it has begun. In the 1978 case of State v. Kenyon, the Wisconsin Supreme Court held that once a criminal proceeding has commenced, the prosecutor's discretion to terminate it is subject to the independent authority of the trial court to grant or refuse a motion to dismiss, quote unquote, in the public interest, a standard that requires the court to consider the effect of dismissal on the general welfare, including the public's interest in having crimes fairly prosecuted and the protection of the rights of third parties. This framework explains why Judge Mogan questioned Mr. Ness regarding the basis for the state's position, including when the state learned of the alleged victim's claimed memory loss and whether some counts could be proven without her testimony, rather than just simply signing the proposed orders.
Well, if I'm hearing from the state that they, from July 2022 until February 2025, had no idea that the victim had a TBI and had an ability to recall certain facts and would not make a good witness, and they can't prove their case, and it's been going on for this long and using all of these resources. I guess it's kind of a quandary for the court. I can't force a trial upon a victim who would be put through the ringer, and quite honestly, a defendant and the public justice system. Resources have already been wasted. So I will sign those two dismissals, and I will see you for jury trial for the felony bond jump violation. And with regards to that case, what I'm going to do is I have cash on the other matters. I'm transferring that to 22 CF 114. I'm making sure that the bond is applicable to 22 CF 114. It is. It looks like it's filed in 22 CF 87, and it says the bond to cover all of the cases, same conditions as previous bond. So same bond, same conditions, same cash.
Following the hearing, the sexual assault case and the companion misdemeanor case were closed, with all charges in both dismissed on the prosecutor's motion. However, the felony bail jumping case did not go to trial as originally scheduled, and on September 24th, 2025, that charge was also dismissed on the prosecutor's motion. This episode illustrates that the power to end a criminal prosecution is not held by any single actor in the justice system, and that the checks each participant holds over the others becomes most visible when a case goes wrong. In Michigan, a judge used dismissal to answer years of stalled discovery, and the people answered in turn with a motion for reconsideration that revived the case. In Wisconsin, a prosecutor concluded that he could no longer carry his burden of proof, and even then, the decision to end the case was not his alone, as the court retained the authority to weigh the dismissal against the public interest before signing the orders. In both courtrooms, the defendants had lived under pending felony charges for roughly 3 years, a reminder that the procedural mechanics of criminal proceedings are not abstractions, but years of a person's life. A justice system that moves slowly imposes real costs on defendants who are presumed innocent, on alleged victims awaiting resolution, and on the public that funds it. And the tools courts and prosecutors used in these hearings exist precisely to keep those costs from compounding unchecked. Let us know if there is a case or courtroom interaction that you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society.